Hello, people are joining, so we'll give that a second. Welcome, welcome. We'll give it just another second. Okay. All right, let's get started. Welcome, everyone. Welcome to this session on contracts and human rights and environmental due diligence legislation. It's a pleasure to be here and to welcome you into this little corner of the Zoomiverse. My name is Sarah Dadouche. I'm a law professor at Rutgers Law School, where I direct our very newly launched Responsible Contracting project. I'm also a member of two working groups, one American with the American Bar Association, and one European working group that is led by Martijn Scheltema and Professor David Snyder. Both of these working groups are developing model contract clauses for companies to introduce into their international supply contracts to address or more effectively address, I should say, human rights issues that exist in their supply chains. A few of our panelists today are also members of the European Working Group. And so what I thought we'd do is just have a lightning round of intros where everybody says their name and institutional affiliations. And of course, if you're a member of the working group, the European Working Group, please indicate as much. So we'll start with first name alphabetical order with Caroline, please.
Good morning, everyone. I'm Caroline Lichuma, and I'm a research and development specialist at the University of Luxembourg, where basically I'm carrying out postdoc research in the broad area of business and human rights. Thank you very much to my panelists and to all the co-panelists rather, and to the host. I'm looking forward to a very great discussion today.
Thank you, Caroline. Claire.
Good morning, everyone, and many thanks for the invitation. It's a pleasure to be here. My name is Claire Bright. I'm Associate Professor in Private Law and the Vice Dean of Nova School of Law in Lisbon, Portugal. And I'm also the founder and director of the Nova Center on Business, Human Rights and the Environment, and a member of the working group working on European model clauses.
Thank you. Daniel.
Thanks a lot for the invitation. I'm a European legal advisor at the Responsible Contracting Project and also coordinating member of the German team for the European Model Contract Clauses project.
Thank you. And Stéphane.
Yes, bonjour. Good morning, everyone. Happy Valentine's Day. I'm a senior partner with the Trinity International Law Firm. I'm a lawyer rather on ground, I would say. And I'd been an expert, member of an expert group with John Ruggie and participating to the drafting of EU model clauses. Merci.
Merci à vous. And correct, happy Valentine's Day. So I'll just begin by setting the stage a little bit, providing some background on the topic, and then I'll invite our speakers to address some pointed questions for us, and then we'll have some time at the end for a collective Q&A discussion. So as far as setting the stage, we know, based on research carried out by Claire and others, that contracts, along with supplier codes of conduct, are the tools that companies use most often in carrying out human rights and environmental due diligence, HREDD. This suggests that contracts matter a lot, at least in the minds of businesses, for managing human rights risks in supply chains. And this in and of itself is, in my view, neither a good or a bad thing. I would say it's just a fact, but a significant fact. What is a little bit concerning, however, is the way that companies tend to use their contracts for carrying out human rights due diligence. And that is to say that typically what we can think of as contracting as usual involves brands using their supply contracts to place all obligations related to human rights on their suppliers, which means that if an adverse human rights impact arises, only the supplier can be blamed or held accountable under the contract. And this is the case in spite of the fact that, as research has shown, the brand's own behavior and purchasing practices can have a very significant impact on the supplier's ability to uphold the buyer's own codes of conduct and human rights standards. So there's something that is a little bit lopsided and maybe unrealistic about the contracting as usual, supplier only, unilateral approach to responsibility. And this approach is also quite fundamentally out of sync with both the UNGPs and the OECD guidance, which, as many of you know, say that all businesses have a responsibility to respect human rights and to avoid causing or contributing to adverse impacts, including through their purchasing practices. This responsibility to respect human rights is, we can think of it as a sort of inalienable responsibility, the same way that we think about inalienable rights. We can think about an inalienable responsibility, one that you can't sort of shift onto others or sort of move onto the other side of the contractual balance sheet via a contractual clause. So that's one problematic aspect of contracting as usual. The other is that when an adverse impact arises, the buyer typically has a contractual right, which it often uses, to immediately terminate the relationship and immediately exit the contract, often without any commitment to considering the harms to the victims of the adverse impact, and without committing to collaborating in providing remediation to the victims of the harm, even if they somehow contributed to the adverse impact. So typically, contracting as usual would say that a buyer can just walk away, can just cut and run, which is also deeply out of sync with the UNGPs and the OECD guidance. So until now, this disconnect between contracts and human rights due diligence was problematic for upholding human rights, but not problematic for legal compliance, because human rights due diligence has until now been a voluntary undertaking, right? Companies can choose to do it or not. But now, and in recent years, with the rise of mandatory human rights due diligence legislation, and with the deliberate hardening of the UNGPs and the OECD guidance into law, we have a very important opportunity to ask probing questions about what role should contracts play in HRDD, and how should the law be tailored to enable contracts to work in the service of human rights and human rights due diligence, not just to manage company risk, but to improve human rights outcomes throughout the supply chain. And the time is especially ripe for this discussion because the Corporate Sustainability Due Diligence Directive, or the CS3D, specifically makes reference to the European Commission developing guidance on model contract clauses for companies to comply with the new legislation. So this is really a good time to be having this chat, and we have a wonderful panel to delve into the issues with us. So with that background, I'll turn to our first question for Stéphane, Daniel, and Claire, which is what do the current laws, in particular the French, German, and draft CS3D laws, say about the role of contracts in carrying out HRDD so far? And we'll start, please, with Stéphane.
Bonjour. In fact, there is no mention of contracts in the French law. It's a law on prevention. It provides for some obligations Is there a role for the contract? In fact, what we can read is that companies are liable for the damage that the company could have avoided if it had complied with its obligations. Therefore, what are its obligations? Are contracts a necessary tool, a mean to comply with their obligations? Those obligations are mainly to prepare a plan and to put it efficiently into, implement it efficiently and to communicate, to identify all risks and prevent those which are the most severe through its activities and impact on human rights, including by those of its suppliers all along the supply chain, or those consequences on human rights they may have. For this, there are some obligations. And the law says that there are, for example, obligation of regular procedure of assessment on what suppliers do, measures to mitigate risk before they happen, the following on measures which have been taken by suppliers, and so on and so forth. How can this be done without a contract with supplier, including and maybe even more, since suppliers have to do the same with their own suppliers at tier 2, 3, or 4. Therefore, judge will make sure that company has complied with company's obligations and therefore might inquire on contracts and the content of their contract as part of the means that the company should have taken in order to participate, has participated to avoid those damages. Therefore, it might be unavoidable as part of obligations of means of company not to have contract. And not only contract, but the content shall be looked at by the judge, which might ensure that it is well balanced, as buyers may not escape from its own obligations of prevention. So at least they will become co-breacher. A contract is to fulfill its obligations to prevent. For not being liable is not only a mean for defense. Thank you.
Thank you so much. And we'll move then to Daniel for the other law that is already on the books, the German law, to discuss how contracts are addressed in that.
Thanks. And thanks for the great introduction by you. That makes it easier to answer this question. Also, the great answer by Stéphane. So, well, basically, the German law is more explicit than the French law, and it explicitly says to companies, you have to do contracts. You have to do contracts which oblige your suppliers to uphold human rights and environmental aspects, and you have to implement contractual control mechanisms. But the law is not silent on the aspects that Sarah mentioned in her introduction. For once, on one side, the law also says you have to do responsible procurement. It does not explicitly say that you have to put this into the contracts. But it says you have to look at your pricing, at your delivery times, at your contract lengths in order to incentivize the right behavior or make it even possible at the supplier level, because a supplier that does not receive enough money, enough pricing that allow him to pay minimum and living wages will not be in the position to do so. And this is an aspect that the German law explicitly takes up. Logical consequences, put it in your contracts as well. And this is also an opinion that is being voiced in legal literature, not only by myself in the article that was posted in the chat already, but also recently in the new ESGZ, the German legal journal, explicitly stated we need contracts, yes, but we need them in the way that Sarah described, in the MCC shared responsibility way. And there are good arguments for this because on one side, yes, the German law is inspired by the UNGPs. The legislator says explicitly that the UNGPs are an orientation for the German law. So this gives us the argument that we should, when the law leaves something open, interpret this in line with the UNGPs. So the law, to some extent, leaves it open if we need shared responsibility contracts or if a mere risk shifting approach is sufficient. But this room, the first argument to pull it in a direction of shared responsibility is UNGP-aligned interpretation with the inalienability to shift your own responsibilities. But there are other even more interesting arguments in the from German law, because one is effectiveness. the contracting and the purchasing practices are preventive measures in the German law. And the German law says explicitly that preventive measures have to be effective. So the analysis that comes from the ABA, MCC, a working group, business human rights models, if you read it through, you see that mere risk shifting is not effective for several reasons. Sarah already mentioned one. If you immediately terminate, it doesn't solve the situation. The other thing is you have to have a cooperative atmosphere with your supplier. Your supplier has to be able to say, yes, there's a problem. And he has to be able to know that he will not be punished immediately if he wants to cooperate. So this kind of cooperative atmosphere is necessary for effective implementation of preventive measure in contracting and purchasing. So this also calls for a shared responsibility approach to fulfill these obligations. And the last aspect that really strongly argues for that is German terms and conditions law. Section 307 of the German Civil Code und AGB-Recht for the Germans. It says you should not in model contracts that you do or in terms and conditions that you have as a buyer unduly disadvantage your supplier. And this is important because, and this is also an opinion voiced in legal literature already. If you just say, you have to guarantee that there are no violations at your level, at your supplier level, but I don't look at my pricing, I don't look at my delivery times, then it is unduly disadvantaging you because I'm essentially ignoring the obligations that I have by law, by the German Supply Chain Due Diligence Act, and just shifting them all onto you. So I really think that the legally safest way to implement these new obligations is following the inspiration of the MCCs, looking at the EMCs. Sure, it's US law, we have to adapt it to the German context, but this is the legally safest way. And some companies are already doing it. I wouldn't say it's mainstream in Germany. Many follow a classical approach, but guidance is, there's more and more guidance also in legal literature that's saying this is not enough, and I totally share this opinion.
Thank you so much, Daniel. Claire, address the CS30.
Thank you, Sarah. So the Corporate Sustainability Due Diligence Draft Directive, the CS3Ds, that was released almost 1 year ago on the 23rd of February 2022, also refers to what it calls contractual assurances and measures to verify compliance with those in various steps of the human rights and environmental due diligence process. So for instance, we see it in Article 7, which provides that companies should take appropriate measures to prevent or at least mitigate potential adverse human rights and environmental impacts that have been or should have been identified. And among the actions that companies are required to take appear the need for companies to seek to obtain contractual assurances from a direct partner with whom they have an established business relationship, that it will ensure compliance with the company's code of conduct or the prevention plan, and include seeking corresponding contractual assurances from its partners that are part of its value chain. It also mentions, with regards to potential adverse impacts that could not be prevented or mitigated, that the company may seek to conclude a contract with a partner with whom it has this time an indirect relationship, with a view of achieving compliance with the company's code of conduct or prevention action plan. And then Article 7, paragraph 4 refers to the need for these contractual assurances to be accompanied by appropriate measures to verify compliance, which includes suitable industry initiatives or independent third-party verification. We also see similar references to contractual assurances and to measures to verify compliance in Article 8, which requires companies to take appropriate measures to bring to an end adverse impacts that have been or should have been identified. Now, this sort of heavy reliance on contractual clauses and measures to verify compliance have been very much criticized in relation to the draft directive, and I think we'll come back a little bit later on that point. For now, I just wanted to mention that in addition, we see a reference to contractual clauses in Article 12 that Sarah mentioned in relation to the need for the Commission to adopt guidance about voluntary model contract clauses. And perhaps last but not least, there is an important reference in relation to civil liability provision in Article 22, which basically provides that companies should be liable for the damage where they fail to comply with their due diligence obligations under the directive, and as a result of this failure, an adverse impact occurred and led to damage. And in paragraph 2 of this Article 22, what we see is a defense whereby companies can use, and that can use that in relation to indirect business partners with whom they have an established business relationship. Basically, what they can do is demonstrate that they have sought contractual assurances, and that through these contractual assurances and through contractual cascading and through appropriate measures to verify compliance, they have actually carried out their due diligence. Now, this clause in itself has generated a lot of concerns. Some have feared that it actually constituted a safe harbor, whereby companies would be automatically exempt from civil liability for harms that were caused by sort of the mere act of including contractual assurances. However, I think it's important to highlight that it is not a safe harbor. It is just part of the due diligence defense, and we see that in particular when we look at the sort of second part of this paragraph 2, which says the defense would not apply if it would be unreasonable in the circumstances of the case to expect that the action actually taken, so the contractual assurances, the measures to verify compliance, would be adequate to prevent, minimize, bring to an end, or mitigate the adverse impact. So here what we see is the standards of reasonableness and appropriateness that refer to an understanding of human rights and environmental due diligence as a standard of expected conduct from a reasonable company, which is very much in line with the understanding under the UN Guiding Principles on Business and Human Rights. And so therefore, and to conclude, what will be relevant here for the courts to determine will be whether it was reasonable under the circumstances for companies to rely on those contractual clauses, to rely on those measures to verify compliance. And it is clear that companies will not be able to simply incorporate contractual obligations into their contract with direct business partners without more, and relying upon contractual cascading to ensure these obligations reach indirect business partners, but rather the judge will actually have to scrutinize the adequacy of relying on those clauses, on relying on verification and auditing schemes in the circumstances of the case. And I would argue that in a significant number of cases, the mere reliance on these contractual clauses and these verification measures by themselves would not constitute at all adequate due diligence. And I think that is something we'll come back to in a second.
Thank you so much, all of you. It's really helpful to hear the rundown of each of these three pieces of legislation. And one theme that emerges that may be surprising is that while the laws don't get incredibly specific about what the contracts should contain, all of them, even the French law, which doesn't even mention contracts, do place restrictions on how buyer companies, in scope companies, should be thinking about their contracts and approaching their suppliers via contract. So extremely helpful. Thank you so much. So we'll move now to the second question, which is a little bit more sort of picture from high level and also on the ground. And this question is addressed to Caroline, Claire, and Stéphane. And it is, in your opinion, what promises and limitations both, do contracts hold for supporting meaningful HRDD? How, in other words, can contracts either support or undermine HRDD? What are some of the challenges of relying on contracts as a component of HRDD? So we'll start, please, with Caroline.
Thank you very much, Sarah. Thank you, everyone. So the short part is the promise part. Yes, I mean, we're having this discussion because there is some potential when we think about the use of contracts in mandatory human rights due diligence laws. And I think the biggest potential is the fact that contracts have the capability to widen the due diligence net, right? Like bring into the law scope companies that are not explicitly covered by the various due diligence laws. So that's the plus side. However, I think my biggest concern with contracts in mandatory human rights due diligence laws is that contracts already exist in a very particular commercial relationship, right? Where there are power asymmetries between buying companies, so big transnational corporations in the global north, and the supplier companies, usually weaker companies in the global south. Now, you're bringing in this tool and trying to fix it in this context of a very particular relationship without changing the structural conditions, which is something, of course, that contracts cannot do. But we have to be aware of this because it means that there's a potential of contracts reinforcing the status quo, so to speak. And when I say reinforcing the status quo, I basically mean that you could have all these contractual provisions, or you could have due diligence laws that say companies should enter into contracts or have contractual assurances for the purposes of enhancing human rights. But then we lose sight of the fact that the point is to mitigate human rights risk and not to minimize the compliance risk of companies. But I'm very skeptical of companies generally, for good reason, we all are. Companies have proven that they're not always in it for anything other than self-interest. So that's problematic. So that means that when I look at these due diligence laws that make provisions on contracts and allowing companies to use contracts for purposes of mitigating human rights risks, I have concerns about the way the laws are drafted in terms of whether the laws will actually make it possible for contracts to have the kind of idealistic hope we have that they will in this particular context. So I'll give two examples in this regard. One, so the German law that Daniel has made reference to does have explicit provisions on contracts, but the German law distinguishes between direct suppliers and indirect suppliers. And it has a sort of a different way to approach company obligations in terms of direct and indirect suppliers. So Article 6.4 on preventive measures requires covered companies to seek contractual assurances from direct companies and to train and implement certain procedures in order to ensure that this contractual assurance can actually be implemented. But it doesn't place such a clear obligation when it comes to indirect suppliers. And that's problematic because it seems to me that we are cosmetically or superficially focused on the top tiers, the visible tiers, and then what happens in the lower parts. Because that's where the global South right holders will really be suffering. If you have all of these laws and we're unable to cascade obligations all the way down to the bottom because the law doesn't place this obligation explicitly on companies, then that's problematic. And I would argue the same thing about the EU directive as well, because the EU directive seems to distinguish in a way or kind of differentiate the obligations in as far as direct suppliers are concerned and indirect suppliers are concerned, because as Claire has mentioned, Article 7.2b of the February draft requires the seeking of contractual assurances, but from business partners with a direct relationship. And then when it comes to indirect partners, Article 7.3 uses the word may. It says may seek to conclude contracts with indirect partners. Now, I feel like giving companies discretion in this kind of way, and I guess that's the crux of my contribution, that I'm worried about the level of discretion given to companies when it comes to entering into contracts and seeking contractual assurances, because discretion is not the friend of global South right holders in this context. Given the choice, companies will always seek to uphold their self-interest, which means that they may deliberately not enter into as many contracts or seek as many contractual assurances as is necessary to get down into the lower tiers. And perhaps that's a pessimistic view of companies, because some companies, as Daniel has mentioned, are actually interested in changing human rights outcomes and contributing positively. But I feel as though the laws that are imposing these kind of obligations on companies must do more to place explicit obligations on the company in order for due diligence within the context of contracts to be truly effective.
Thank you so much, Caroline. Stéphane, would it be all right if we move to you next on this problem of the promises and limitations of contracts for HRDD?
Yeah, it's not an easy issue, by the way. My first thought is to say that contract cannot be a miracle. It is not a miracle. And the law neither. So above contract, above the law, above anything, there is a matter of willingness. And you know that willingness is the basis for any contract, by the way. So this is a complex issue for that matter. So there is a need of drafting and there is a need of willingness. They need a need of drafting and the need of good implementation to achieve the goals. What is the goal? We know it. Is a reconciliation between business and human rights, profits and dignity. And this throughout, and this is very unique, throughout all the supply chain worldwide. And we are not all with the same culture, with the same constraints. We are all different. No one side can impose to the other one its rule. It can say about the same goal, but maybe the processes can be a little bit different and be adapted to different culture, to different constraints. So how to achieve a positive outcome is to look at differences between people, constraints, countries, and systems. So to deal with suppliers with different culture, different pressures sometimes, and also for the people, as for example, when we speak of child labor, it concerns the child, but the families and communities. How can it be required by a rule? There is maybe a need of deeper due diligence on consequences of whatever we decide, as many human rights cannot be achieved, an outcome cannot be achieved in one day. It can take time. Buyers and suppliers need to partner to achieve positive outcome through due diligence, which are tools which have to be clear, well-balanced, realistic, and feasible. It cannot be one-way drive, but it must be partnership. To some extent, we could speak of some sort of free, prior, and ongoing informed consultation amongst the stakeholders. Nothing can happen if there is no willingness or one rule imposed by buyer to suppliers in a different world. Positive outcome requires positive mindset. It requires acceptability. And this is where the rules must be very educational for suppliers and for more than punitive, even if it has to be somehow punitive for some buyers misbehaving, as Caroline was sometimes rightly underlying. Suppliers have to deal also with the tiers 1, 2, 3, 4, and above. And they are not always aware of what is human rights is on ground, and even less for those tier 2, 3, 4, 5, and 6. That's new to them. It was new to our world. It is even new also for the other world. So there are some concerns, and there is exactly the same as to know what is the environment and constraints. And this is where human rights due diligence can be positive and have positive outcome. To have a contract only to benefit for the purpose of mitigating risk for buyers is not sufficient. There is a please, there cannot be a defense. Positive outcomes in respect of human rights in sustainable manner and rights of victims. To identify ways in time to a positive outcome. It cannot be all the time and for all human rights immediate outcome. It can take some time. There's, for example, child labor. It's specific human rights, like it should entail specific due diligence, like any other human rights. They are all different in different contexts. Environment can entail different due diligence, as for example, decarbonized economy needs transition and some time to achieve it. So business sometimes in some circumstances can, for applying their rule, go with a cut and run, when in fact for supplier, they don't know even what is happening in tier 4 and ignore. So how to reconciliate positive outcomes on the long term with acceptability and with respect of human rights? There is a need of responsible entry, but also responsible driving, training, education, and awareness, and responsible exit at the last resort. The session of today, a responsible contracting, and not to create worse situation for kids, families, and others. And in that regard, with some lawyers, and I know that Professor Alan Franklin is listening to us from Cambodia, we are considering a charter for transition, especially concerning child labor. Also implementation. How can we impose necessity all along the supply chain to companies? It can be unrealistic and feasible. And this is where there are some new means with new technology. And we can call companies to consider the blockchain with a legal platform with objectives, as for example, for peculiar child labor problem, to test for improvement in time of what the companies are doing in partnership with on ground. Thank you.
Thank you, Stéphane and Claire.
Thank you. I'll be very brief because I agree with what's been already so eloquently said by my previous co-panelists. Simply just to re-emphasize a few points. First of all, on the promises of contracts, and as you were saying, Sarah, from the start, contracts are indeed one of the most useful tools in practice by companies to do human rights and environmental due diligence. That's something we saw, for instance, in our study for the European Commission on due diligence requirements through the supply chains. And it's a tool that companies are already well familiar with. So it is helpful to include that tool rather than try and exclude it altogether. Now, as been previously mentioned, contracts are not the silver bullet. And I think it is very important to emphasize that it is just one, albeit an important one, means to implement human rights and environmental due diligence. So in other words, what it should be is part of the human rights and environmental due diligence toolkit, but it is not a proxy for it. And I think that's where really we need to make that difference. Just a few more points that I'd like to emphasize. Contracts are sometimes and quite often seen with concerns by stakeholders in civil society. And I can understand the concerns because they are sometimes used in practice to displace responsibility from the buyer into the supplier. And so it is really essential to craft contractual clauses and to craft legislation appropriately to ensure that contracts are not used in a way of outsourcing due diligence obligations, that they are not used in a way that actually places all the responsibility to respect human rights and environmental standards onto suppliers, that are not used as a way to de-responsibilize buyers or to shield them from liability, but instead really embedding the principles of shared responsibility between the contractual partners. And it is also important to refer to these power asymmetries that Caroline talked about earlier, and see how this needs to be embedded into contractual clauses and need to be reflected appropriately, to take into consideration the role of the buyers' purchasing practices in potentially contributing to harms themselves. And again, that's something that needs to be reflected in the contract, in the contractual clauses themselves. And perhaps in particular, I'm thinking about all the sort of clauses of pressure that can be put by the buyers in relation to pricing, in relation to the timing of an order, the last minute changes to the quantity, the delivery schedule, etc., which in turns means that suppliers may not be able, for instance, to pay wages or adequate wages. They might have to use undeclared work, they might have to use child labor, they might have to demand unpaid overtime, etc. So these are all situations that may indeed contribute to the creation of the conditions for the violations to occur. And it's important that these are adequately reflected in contractual clauses, in legislation that talk about contractual clauses. So the idea is really to use contractual clauses and do it well so that it can actually help uphold human rights and labor and environmental standards in global value chains rather than hinder them.
Thank you so much. So I think this is a really nice segue into our last question, which is open to all the panelists, and I hope will lead us into a discussion with the audience as well, which is, you know, now that we've sort of discussed some of the promises and limitations of contract, what do we think about legislation? We've already kind of started to inch toward that. It seems like one of the themes from what each of you shared for the previous question is that contracts aren't a silver bullet. They have to be, they cannot be a shield to liability on their own. They are a useful and important component of HREDD, but they shouldn't be a proxy for HREDD. And you know, significantly that HREDD is a sort of ongoing, alive process that requires, as Caroline was saying, a lot of that sort of hard work of actually going in to the supply chain and seeing with an eye toward mitigating and preventing human rights harms from occurring, not only with an eye toward managing company risk. So all of these themes, how do they translate into legislation and into contracts themselves? So what advice would you give to firms in rethinking their own contracts to be aligned with due diligence principles? So what are some of the key attributes that you would attach to due diligence aligned contracting that would also allow us to move in a meaningful way away from a regime of contract-based due diligence toward a really robust HREDD regime where contracts are supportive of that process? So I will open it up to everyone, but maybe we'll start with Daniel and then take it from there.
Thanks a lot for the question. I already wrote a bit on that in the chat on the great question of Robert McCorkadale. For me, it's I mean, for me now, if I'm advising German companies, I would tell them to put in their contracts these principles. Yeah. HREDD obligation instead of a pure warranties representations approach. More realistic. You can use some warranties on some very specific situations in the own operations of the supplier, but if it's to the supplier's supply and if it's complex issues, you should have HREDD-based obligations of means of risk management, because the opposite is unrealistic. The second thing would be own procurement obligations. The supplier needs the security that pricing will be dealt with in a human rights respectful manner, that delivery times will be dealt with in a human rights respectful manner, and that there will be a room for conversation, a safe room for conversation on these issues, that the supplier can say, hey, I have a problem because you did it like this, and does not have to be scared that he will be punished by termination or something like this, because this could be with the wrong contracts. This could be what happens in the supplier's head, because he could say, oh, I'm contractually obliged to guarantee that there are no human rights problems at my sites. So if I say there's a problem because of your procurement practice, dear buyer, then the buyer might terminate the contract immediately. And another very important thing to me is responsible exit. As Stéphane mentioned, this is a very important topic, because some problems are not solvable overnight. Some problems take time, and there it should be sufficient if the supplier cooperates and makes the situation better. It should not be an automatic reaction to terminate contracts if there are problems. And I would say that these are principles that should explicitly guide the European legislator, like in the Lara Walters report from November, that I can also I put it in the chat in the Q&A. I think she really gets this point, and she really puts it in there. She says shared responsibility contracting, responsible exit, own procurement, all these things are in there. And I think it's important also for SMEs. Because if you think also about SMEs in Germany, in Europe, it's not only suppliers in the global south. SMEs in Germany, in Europe are often feeling overwhelmed right now, because what is happening is that big firms are often telling them, okay, you have to do it like this, guarantee me there are no problems. So I think this would be my advice to the legislator and also to the business, to really focus the contracts and the legal obligation on the contracts in the law on these three principles.
Thank you so much. Caroline, can I turn to you?
Yes, thank you very much, Daniel. And I think, I mean, he's really adequately summarized some of the concerns that I have as well. But what I would add is, I feel like the law, especially the EU directive that is still being negotiated, should do more to solidify the obligations of companies in as far as contracts and contractual assurances in HREDD is concerned, because discretion to me is the enemy of progress in this regard. If we give company wiggle room, they will use that wiggle room, and they will not do as much as they possibly could to use due diligence contracting in order to mitigate human rights risk. So there should be clear obligations imposed upon them so that they know that, you know, when you enter into due diligence contracting for these purposes, this is what it means. And in addition, it should be explicit that these due diligence contracts do not shift responsibility, as Claire mentioned, and as the Lara Walters draft also emphasized. She included a new amendment saying that when you have contractual assurances and contracts, it does not result into a shift of responsibility, which I think is important, because there's a risk that some companies might try to play this card, even though I know, Sarah, you're not concerned that this is such a major risk. I read in your article that it's very good. But yeah, and secondly, I feel as though another way to strengthen, you know, the potential of contracts in due diligence laws is to do away with this distinction between direct and indirect partners and impose, you know, as much as possible, impose obligations, because as Stéphane was going, this distinction means that tier 1 suppliers, tier 2 suppliers may be covered, but lower down, we're still going to have gray areas. And that's problematic, because it means that vulnerable rights holders in the lower supply chains may not be as protected. So perhaps it may be useful to actually have these obligations being imposed on all business partners. And then thirdly, I would say the shared responsibility approach is very important, but I'm more concerned about what can be done to, within the context of the contractual arrangements, create room for other stakeholders, so other contractual stakeholders, right? So what can, or how can contracts within this context of due diligence create spaces for workers, for local communities to actually be able to take part in these due diligence processes or have a say? I don't think that's as yet is something that, you know, the laws as they are make it like mandatory for companies to do. but maybe it should be a requirement that when they're cascading contractual obligations or imposing contractual obligations within the context of due diligence, that there should be some space opened for contractual stakeholders such as local communities and workers to actually take part in these due diligence processes. Because again, the suppliers who are the key contracting party may not always have the same interests as local communities, as workers, as other affected right holders. And unless these people come on board somehow, then due diligence contracting is going to be cosmetic compliance with the human rights due diligence laws.
Mm-hmm. Thank you. Claire, and we'll I know you shared a few things already in the previous question, but we'd love to hear from you and Stéphane briefly, and then we just have 10 minutes left. So mindful that there are a couple of questions here already that we can address.
Sure. Just briefly, I'd like to come back on some of the provisions from the Lara Walters proposed amendments. Caroline and Danielle already mentioned some. I think here there's some suggested amendments that are really worth mentioning. In particular, the Lara Walters draft talks about reasonable and equitable contractual provisions with business relationships that participate in carrying out due diligence. And I think that's really important, linked to what we were discussing, the idea that contractual clauses are part of human rights and environmental due diligence, but not a proxy for it. And also seeking to address the power asymmetries by, talking about what is reasonable and equitable that, we talked about earlier. It also get rid of that distinction between direct and indirect contractual relationship that Caroline was talking about. And highlights quite clearly that contractual assurances, but also verification schemes are not sufficient by themselves to satisfy the due diligence requirements of the directive. And that's really important to sort of avoid the tick box approach that I think we need to be very mindful about if we want the law to actually have meaningful impact for the people on the planet and not just be one of those tick boxes besides that companies do, but that don't have implications on the ground. Just to finish very briefly, other important suggested amendments, in particular the Lara Walters draft referred to the need for, when companies seek contractual provisions, to assess whether the business partner can reasonably be expected to carry out due diligence, taking into account a whole range of issues, and to consider any support that they might need. And again, I think that's really important in light of what we've discussed, the asymmetry of powers, the special particular needs that SMEs often have to have that extra support in order to be able to carry out due diligence requirements, because they often lack capacity to implement these measures. And the need to have really to understand these clauses as a sort of shared responsibility for due diligence between the contractual parties, etc. And one last point concerns the civil liability provision, where the Lara Walters draft talks about the due diligence defense when a company can demonstrate that it complied with its obligations under the directive. So it's no longer a defense that is specifically tied in with contractual assurances and measures to verify compliance like the Commission draft. It's more general about the due diligence measures that it has taken, and these would be part of it, but it highlights the fact again that it's not the only part of it, and it's much wider than that. And I think that's also interesting to highlight that, and I will stop here.
Thank you so much. Stéphane, last word, and then we have a
30 seconds, because I know the time is short. Everything has been very rightly stated. So 2 points with a little bit of a different perspective. First, we should think also of the law in the countries of suppliers. That's not only the law of business, it's the law of the states to protect business human rights. It could make it easier due diligence if the suppliers had some driver from their own state and how to better share that responsibility. So that's not only the law in our countries, it's also the law abroad. The second thing is grievance mechanism. We could think that through grievance mechanism, there can be an improvement in due diligence and in real partnership with the stakeholders in order to achieve a real acceptability. I will stop there. Thank you.
Thank you so much. So much good content. We could carry on, but we have only 5 minutes. And we have 2 questions so far. If folks have more, please go ahead and add them to the chat. But the first one, I thought maybe from Brian Wang, it has 2 parts, but the civil liability piece, I was wondering, Claire, if you could address it. So he asks, the CSR HREDD introduced civil liability. However, the civil liability in the French duty of vigilance law has encountered many criticisms from commentators. From the French perspective, actually, so this could be Claire or Stéphane in particular, would the civil liability as contemplated in the CSREDD be viewed as effective or not?
Well, so I think the starting point is whether it's a right, there needs to be a remedy. And so the civil liability part is, in my view, absolutely key in ensuring that the human rights and environmental due diligence obligations are taken seriously. Now, there remains a lot of obstacles to access to justice that will be faced by claimants and that haven't been addressed in the CSREDDs. So obviously it will be also a test and kind of a test and trial, and it will depend a lot on the judges and what they consider, especially because we talked about the standard of expected conduct. So what the judges consider reasonable under the circumstances of the case. But I do think that it can play a really important role, and we can see the dissuasive role of some case law that already exists, and I'm thinking right in the Shell case and in relation to climate change. We can see how this case has triggered a lot of reactions from companies already. So I think it is an important part of that puzzle.
Thank you. And Stéphane, do you have thoughts on that?
Well, very shortly, there is no decision for civil liability at present before the courts. There are only some injunction procedures which are put before the courts in order for the courts to decide whether or not there should be some improvement in the plans which have been prepared by the companies. So this is where we stand today. The second thing is that indeed, as it has been underlined by the Constitutional Court at the time of the discussion of the law on its constitutionality for concerning the possible fines, that the terms of the law are sometimes considered as being vague or subject to interpretation. Therefore, the power of the judge as sovereign is going to be quite important. And the third point that we shall see at the time when and if those cases are appearing before the court, there is one big retailer shop, is the burden of proof. And that would be an interesting comments, because we know that there are 3 obligations for companies: to have a plan, to implement it efficiently, and to communicate, to publish it. Therefore, lots of information will be put at the disposal of the judge. Therefore, how the judge is going to consider what information the judge has and what information it should have from victims in terms of the causality issue. That will be some sort of distribution, maybe, of the proof, and that would be interesting developments that we have to expect. Lots to say. That could be a single session only on those issues. Thank you.
Mm-hmm. Thank you. Daniel, could you please address Paul's question? So he's asking, and we'll stop in just a minute. Sorry, but I do think it's one we have been thinking about. So I wanted to invite Daniel to address it. He's asking, whether the clauses that we've been developing consider the buyer's responsibility when a supplier goes bust, or there's like a big problem at the supplier level, or you realize maybe you're dealing with a bad supplier, which of course can happen. So I'll pass it on to Daniel for that.
So it's a very relevant and also difficult question. I would say in the first question, yes, we have been thinking about this problem that we have a pricing clause in the MCCs, and we are thinking always about all our MCCs, how to make them better. And one thing we've been thinking about, because this has been addressed by a company we are working with, they said, but what if the supplier's management just uses this pricing clause to say, give me more money, and then backs the money? So we have been thinking about a solution for this, where there's an explicit obligation for the supplier to document how the raised pricing has been contributing to making situations for workers better. And if he can't prove that, then the buyer can call this money back. And if there's a dispute about that, then a third party can be asked, a third party expert to resolve this issue. But the other part of the question is a bit more complex. What happens when the supplier goes bust? Because this is really a difficult issue, because I have to say we don't have a solution for this yet. And it's also the question how far the responsibility of the buying company goes. I would say it depends on the case of hand, because if it's unrelated to the actions of the buying company or any HRDD failure of the buying company, I guess we would not say that the buying company has to be responsible, but it can be that the buying company did contribute, and then the question would be to third-party rights. And I put that answer already in the chat in responding to another question. There is a recommendation on third-party rights in the MCCs 2.0 that you can use. I will post it again if you want to, but you can see it in the questions answers already, and you could use this clause for this situation, and that would be a good idea.
Okay, thank you so much. We're sorry for going a couple of minutes over. We would just invite anyone that wants to follow up with us about the European model clauses or the ABA American model contract clauses to reach out to us. Olivier is going to put an email address where you can reach out to us at the Responsible Contracting Project. We're 100% available. And thank you so much for joining. Thank you so much to the panelists. This was amazing. And see you next time.
Bye-bye. Thanks a lot.
Bye. Thank you.
Bye. Au revoir tout le monde.